We are recording.
Good afternoon, everyone. Welcome to the appellate court. I'm Judge Bright. I'm sitting this afternoon with Judge Elgo and with Judge Clark. I want to welcome Judge Clark, the newest member of the court, who is sitting with us for the first time today. So, welcome, Judge Clark. We're hearing the matter of State versus Collins. AC docket number is AC 43030. The argument is being conducted over the Teams platform, which means everybody is participating via video conference. The argument is also being streamed live over the branch's YouTube channel. So I would remind counsel, to the extent there's any protected information in this case, that you be careful not to disclose any of that protected information. I'm going to ask everyone to introduce themselves, starting with the judges, then counsel for the appellant, then counsel for the appellee, just to make sure we can all hear each other and see each other okay. Again, I'm Judge Bright.
I'm Judge Elgo.
And I'm Judge Clark.
My name is Freeman Demersion, representing JIQUANE Collins, who's currently incarcerated, and I'm a temporary assistant public defender with the Office of the Public Defender.
Good afternoon, Your Honors. Brett Aiello. I'm a Deputy Assistant State's Attorney. I represent the state of Connecticut in this matter.
And I can hear everyone and see everyone okay. I assume that's true for everyone else. If at any time you're unable to see anybody, please let us know. And if you're unable to hear anybody, please let us know. If you get disconnected from the argument for whatever reason, please go back to the link and click on it. We will suspend the argument until we make sure that we have everybody present. I'm going to ask everybody during the course of the argument to keep their microphones muted. So except when you're speaking, obviously, to make sure that we don't have crosstalk over each other, and we cut down on as much background noise and feedback as possible. I would ask, though, that you keep your cameras on at all times so that we can make sure everybody is present and fully engaged in the argument. And I'll remind everyone that although we are not physically in the courtroom, this is a court proceeding, and we expect counsel to behave the same way they would behave if they were standing before us at 75 Elm Street, which we hope to get back to doing very soon. The judges are going to also keep our microphones muted when we're not talking. We will raise our hands if we have questions, and ask counsel to recognize us. Again, we're trying to avoid talking over each other. If you do not recognize us because you're engrossed in your argument, have your head down looking at your notes, we'll just jump in at that point. But again, we would prefer if you could if Judge Elgo raises her hand, just acknowledge Judge Elgo and let her ask her question. Each side will have 20 minutes to argue. The appellant can reserve time for rebuttal. I am going to keep the time. We do not have our light system in my chambers, so I will hold up a sign when you're at 2 minutes, another sign when you're at 1 minute, and a sign when your time is up. So try to pay attention to that. Attorney Demersion, are you prepared to proceed?
I am prepared, Your Honor, and I'm sorry, I wanted to state for the record that also present is Senior Assistant Public Defender James Strito, who's present but not on camera.
Okay. How much time would you like to reserve for rebuttal?
5 minutes, Your Honor.
All right, you may proceed.
May it please the court, turning your attention to issue 1 of the defendant's brief, the ultimate issue testimony from Detective Peck. Your Honors, in short, Detective Peck, the state asked Detective Peck a question that was supposed to be framed as a hypothetical, but functionally identified Mr. Collins and the drugs seized, which was ultimate issue testimony, Your Honor. Detective Peck testified that somebody in possession of exactly 121 bags of crack cocaine and 14 bags of heroin would be selling and not using. Now, he identified the defendant by using the exact quantities seized. Because those numbers were so specific and unique to the facts of the case, but these facts didn't come out of thin air. Now, Detective Peck was the investigating officer, the arresting officer. He himself seized the drugs. He testified as a fact witness, and then before any cross-examination, he was sworn in, re-sworn in as a expert witness and testified to those facts again. So we have the expert witness who was the arresting officer essentially vouching for his own decision to arrest in the first place. Now, he's testifying to the facts at issue, saying a person in possession of the drugs found, not just some random 121 bags, but the 121 bags seized. The person in possession of those drugs is selling, and that's textbook ultimate issue testimony.
So,
Yes.
so if the hypothetical question had been 105 bags, no issue?
I believe it would still be ultimate issue testimony, but it would be significantly less prejudicial.
Well, how would that be ultimate issue testimony if it wasn't ultimate issue testimony in Nash?
In Nash, the state used a range of drugs. I believe the state asked the defendant if you found somebody in possession of 20 to 30 bags, would that be consistent with somebody using or selling? And if I remember correctly, the defendant in Nash was found with 38. So what's interesting about Nash is that the state actually took precautions by not using the exact quantity of drugs seized, but even more significantly, they used a range of drugs. So to sort of insulate the jury from the exact facts of the case. So the facts still bore a true and fair relationship to what was actually seized in the case, but they took those precautionary measures. And that's why.
So in this case, are you saying that if the question had been, if you found someone with 100 to 110 bags, that would have been okay, but the precise number was not okay?
In this case, I don't believe it would be okay. I believe it would still be ultimate issue testimony because of the fact that Peck was the arresting officer, and there's no indication in Nash and other case law that they were reusing the arresting officer as a fact and expert witness. So in this situation, even if Detective Peck was asked a lower range of drugs, it would still be ultimate issue testimony in this particular case, just because the jury was bombarded by Peck's testimony about this exact quantity of drugs, and not only about the quantity of drugs, but Peck had just testified at length as a fact witness about what Mr. Collins' apartment looked like, how the drugs were packaged, the value of the drugs. Now, he was so pervasively involved in the case that this question couldn't properly be called hypothetical when asked to him.
But was there any objection to Peck testifying as an expert witness because he was also a fact witness?
There was not. And
is there any case law that you're aware of which says a fact witness cannot also testify as an expert witness?
I don't believe so, Your Honor, and that's not an issue we're raising here, but I believe it speaks volumes towards harm and towards the prejudicial effect of this the statement or the opinion that Detective Peck gave.
Well, it may have been terribly harmful and prejudicial, but if it were nevertheless not error, that just means it was bad for your client's case. So returning to Judge Bright's question, I mean, are you asking us to create essentially new law here in Connecticut that would say in the event a witness is both a fact witness and an expert witness, what might otherwise be permissible in Nash is now impermissible? And because I've correct me if I'm wrong, but I haven't seen any Connecticut case law that holds, at least, you know, in this context, anything like that.
If you're asking me from a policy standpoint, I believe that would be a good rule. And we're not raising that issue in this case about the fact and expert witness. We're talking specifically about Detective Peck identifying the defendant by using the exact quantities of drugs, describing his apartment, details of that nature. But from a policy standpoint, I believe that would be a fair rule for the defendant, because when you reuse a fact and expert witness, it forces the party doing that to tread carefully, and that's not what happened in this case. The state used that as their trial strategy. They decided a week before the start of evidence that they were going to reuse Detective Peck as an expert witness and a fact witness when they had originally planned on calling an outside officer. So they picked their strategy, and they had to tread carefully, but they didn't do so. Detective Peck testified to this ultimate issue, and it's not any ultimate issue. It's specifically on the defendant's intent, his state of mind, which is forbidden by the Code of Evidence and General Statutes 54-86I.
Well, he didn't. At no point was he asked specifically, nor did he answer the question whether or not, in his opinion, this particular defendant possessed drugs with the intent to sell, which is actually different from what the Velastra and progeny cases involved. Here, The question was posed as a hypothetical, and the question was, would it be consistent with use or sale for a defendant to possess this amount of drugs, right?
That's correct, Your Honor. It was framed as a hypothetical, and he didn't use the defendant's name. He didn't say Mr. Collins. But Villa Lastra, the second question in Villa Lastra, which was found to be improper ultimate issue testimony, the court there held that the expert is not allowed to identify the defendant by referencing the exact drug seized, and by switching the phrase drugs or items seized with the exact number seized. I think that's the functional equivalent of using the item seized. Remember, it's not a random 121 bags. This evidence was created by Detective Peck. It's the 121 bags found on scene. And I believe you mentioned the line of cases following Villa Lastra. Turning your attention to State v. Wright from 1998, the expert there, I believe, didn't use the defendant's name, but used the phrase "the person that had those," referencing the item seized, and that was found improper ultimate issue testimony, and not just improper, but that was actually found to be harmful error because of the lack of other evidence on intent to sell. And I think our case is very similar to Wright because our defendant is similar to the defendant in Wright. In both cases, there's no guns or weapons found, items commonly found with narcotics dealers. There's more significantly, there's no evidence of drug dealing. The jury never heard any evidence about drug sales. And that's common to both Wright and our case. There's no beepers, no sale records. There's no ledgers, documenting drug transactions.
What about the tear bags found in the outlet?
There were tear bags found in the outlet. I believe it was only 5. And I believe that low number of bags indicates supports trial counsel's strategy that he was a user.
Yeah,
Why would a user have any tear bags?
I'm sorry, Your Honor, could you please repeat that?
Sure. Why would a user have any tear bags at all?
Well, theoretically, they would be purchasing narcotics and then just putting the bags anywhere. But I understand your point, and I believe that while there were tear bags in the apartment, there was a lack of other evidence indicating intent to sell. Specifically, there was no conduct of drug sales admitted to the jury.
Counsel, but for the exact number being objectionable in the testimony and or even some range that's close, notwithstanding Nash, you don't have any disagreement that with respect to the inference of intent, that the inference of intent by virtue of the large number of bags of cocaine that a hypothetical person, was holding, the inference of intent to sell is fairly routine and not something that is, that has been established law, correct? That you can have and you can take an inference from the fact that even a hypothetical person having that quantity of crack cocaine is you can make that the jury could have made an inference that there was intention to sell, correct?
In some cases, yes. Intent is generally proven through circumstantial evidence where inferences are drawn.
And the amount of crack cocaine, when it's testified to by an expert or anyone who has a basis for knowing that is a proper inference to make, correct?
It can be, but I believe the inference was unfairly pushed upon the jury by the fact that we have the arresting officer vouching for his own decision to arrest, where they're drawing that inference when they may not have done so. If an outside officer had been testifying to this, like the state's original plan was.
That is a key distinction between this case and Wright, where the error was found to be harmful. The amount of drugs found on the defendant in Wright was significantly smaller than 114 separately wrapped bags of crack and cash in an amount that the jury might reasonably find to be more than you would expect this defendant to have given his income as was established at trial, correct?
That's correct, Your Honor. The drugs were substantially of less quantity in Wright, but I'd like to point your attention to the heroin issue. Now, Mr. Collins was convicted on 2 separate counts of possession with intent to sell. And if you look at Detective Peck's testimony regarding the heroin, he said the 14 bags is not an exceptional amount, and that could go either way. Now, this is very problematic because there was substantially less heroin, but Detective Peck, he said it could go either way, but then he said again, and the key language here is again, he looped back to his fact testimony. He said that Mr. Collins' apartment was neat, it was sparsely furnished. He said, I've never been in drug users' houses that weren't all messed up with bags and very, very disorderly from users being unable to maintain, stuff like that. And then the jury would not have inferred that a user of heroin or somebody in possession of those bags might be a seller.
But what we're talking about here is the denial of a motion for mistrial, right? So let's talk about the heroin. On the heroin, the sole basis for the denial or for the motion for mistrial was the statement that you quote on page 5 of your brief. If an individual involved in the use of heroin, 14 bags is not an exceptional amount of heroin. However, you would have items that you would see associated with that. That testimony was the basis for the you have 2 minutes left, by the way. That testimony was the basis for the motion for mistrial, right?
Yes.
The earlier testimony, the fact testimony, was not the basis for the motion for mistrial, was it?
You mean, Judge, with respect to the place being unkempt and so on, is that
correct?
Yep.
The basis for the motion for the mistrial was just the quantity,
right?
Not the condition of the apartment, right?
That's correct, Your Honor.
So the argument you're making on appeal is different than what was made below at the trial court.
I'm not trying to raise this as a separate issue, and I'm saying that it speaks to harm, the fact that he's looping back to his fact testimony. But you're correct, Your Honor, that the basis of trial counsel's motion for mistrial was on the fact that he used the exact quantities of drugs.
And Counselor, he was sentenced to the identical concurrent sentences, right, with respect to the crack and the heroin?
He was, I believe, 12 after 7, Your Honor.
And they ran concurrently?
Correct.
Okay.
Your Honors, turning your attention to issue 2 briefly. Again, this issue was not some minor prior misconduct issue. This is the state's witness violating an order in limine. The state moved for a motion in limine to include and submit to the jury evidence of prior misconduct, specifically an earlier arrest that was nollied as part of a plea deal. And then Detective Yates, or Sergeant Yates, excuse me, spontaneously interjected a statement that Mr. Collins had been involved in other incidents with the Middletown PD, and not just the PD, but the narcotics unit.
And what the question was, how do you know that he's lived at this apartment for some period of time, right? And the response was, what was the response exactly that you are claiming was harmful error?
I believe it was, he said, I believe from other incidents that involved him, yes. And then I believe that's paraphrasing, and I don't think that's exactly it.
Okay. It wasn't as though well, okay.
Attorney Ayala, are you ready to proceed?
Yes, Your Honor. Good afternoon, Your Honors. Again, for the record, my name is Brett Aiello. I'm a Deputy Assistant State's Attorney. I represent the state of Connecticut in this matter. Your Honors, the trial court properly exercised its broad discretion in denying the 2 motions for a mistrial in this case. And it bears emphasizing that we're not only talking about just any discretionary call by the trial court, This is a discretionary call that our courts have said is not favored. It's a drastic remedy. It's fit only for a circumstance where a party cannot have a fair trial and essentially the whole proceedings are vitiated. Turning to the substance of the evidentiary claim, as Your Honor has discussed, starting with Detective Peck, he offered what was a completely proper opinion on a hypothetical question under our rules of evidence. Why is that? Now, Peck was not asked, nor did he offer an opinion on the ultimate issue, which is whether this defendant possessed these narcotics with the intent to sell. The question referenced a hypothetical individual, and the state merely asked, as Your Honor referenced, whether the quantity of narcotics was consistent with selling and using. And just building on that, our case law has discussed that the quantity of narcotics, the significance of the quantity of narcotics in such a case is not something that's within the common knowledge of your average juror. So the jury here needs some relevant kind of context to place the evidence in. And that is borne out, by our rules of evidence, which says that the evidence underlying the hypothetical situation has to be relevant to the issues in the case. So it was perfectly acceptable under Rule 7-4C for the state to inquire using the number of narcotics found in this case, the 121 bags of crack cocaine. And again, asking generally, not whether this defendant possessed these narcotics with the intent to sell, but whether that quantity would be consistent with selling as opposed to using.
Has the state abandoned any claim that if there were error, it was harmless? There's nothing in your brief on that issue.
So the state didn't brief harm, Your Honor, because just because we're only talking about a motion for mistrial, and again, I note the defendant, didn't object to this testimony. So the first time it's raising it is within the context of a motion for mistrial. So it is, from the state's view, the defendant's burden to show that this was such an error that it vitiated the entire proceedings. I believe in the state's brief, the state did reference the other evidence that came in regarding the evidence that was seized, the cash, the tear bags. So
I guess I'm just asking, I'm trying to ask you very directly, given that you're now representing the state in this appeal, does the state contend that if there were error, it was harmless or not? That's the question I'm trying to get my head around, because you didn't brief it on appeal.
Yes, the state's contention is that if there was, well, I guess not necessarily, because we're talking about a motion for mistrial. So if the issue is just to, if we're talking about the evidentiary issue, then certainly that would be harmless. But we're talking about the evidentiary issue in the context of a motion for mistrial. So if the trial court erred in denying the motion for mistrial, then prejudice is presumed essentially under that in that context.
So your position is we have to determine if the court abused its discretion in denying the motion for a mistrial, and if it abused its discretion, it means we've said they should have granted a mistrial, which means there would necessarily be prejudice.
Correct.
Okay, I got it now. Okay.
But you chose not to make that argument in your brief. But that's still your position on appeal. Okay.
Correct.
Okay.
With respect to the heroin, I'm not sure that it helps the defendant that Detective Peck testified that the 14 bags could go either way. It's hard to see how a neutral answer like that could be so prejudicial to the defendant to vitiate the entire proceedings. And I do want to go back and touch a little bit on this idea of the mistrial, because it's important that in evaluating this claim, the context of this particular claim, the defendant essentially bypassed any means of mitigating any harm. So the defendant is supposed to, in fact, I note that the trial court in its pretrial instructions to the jury noted that it was the defendant's, or the party's obligation to object to matters it found objectionable. And of course, it is counsel's duty to contemporaneously object to give the trial court an opportunity to rule at the time. So curiously, the defendant notes that this ultimate issue was something that was potentially on the horizon and cautioned the court against admitting that. However, it's curious that when it came time and the state asked the question that asked for Detective Peck's opinion, the defendant didn't object, waited for Detective Peck to offer an answer. And in fact, 2 pages later, as the state transitions to its questions on heroin, it then signposts its similar question regarding heroin as to whether the defendant possessed the heroin with intent to sell. Again, the defendant did not object. So that's curious. It, to me, strongly suggests that the defendant was aware of exactly what the state was going to ask and allowed this testimony to come in with the intention of asking for a mistrial. Didn't ask to strike the testimony, didn't ask for a curative instruction, but I would note that there was a charging conference on the record, that the court provided, in the state's view, a comprehensive instruction on expert testimony, and specifically with respect to hypothetical questions, that the jury, of course, like any other witness, could accept or reject that testimony in whole or in part, that the weight of the opinion would be connected with whether the facts assumed within that hypothetical were proved within the trial. So I note that I think it's significant the defendant didn't ask for such an instruction, but nevertheless, the court gave a pretty comprehensive instruction on expert witnesses and hypothetical testimony. Just briefly with respect to Sergeant Yapes, he testified on cross-examination that he knew where the defendant lived from other quote, other situations, unquote. And this testimony also was not so prejudicial for the defendant not to have had a fair trial. And the state's primary argument here is that the defendant misses the mark because he essentially invited this testimony by Yapes by pressing him on his knowledge that the defendant had lived there at 135 Butternut, quote, for a while. So when he provides that answer, that is Sergeant Yapes, that the defendant had lived there for a while, the defendant asked him, quote, "You know that? That was part of your investigation to determine how long he lived there?" So Yapes' answer that, quote, other situations, was not only responsive to the question asked, but it was vague enough that it didn't explicitly say that this was from prior arrests, prior criminal involvement. And so just to, again, place this in the proper context of a motion for mistrial, in addition to these motions, to it not being favored to grant these motions, our courts have said that the trial court is in the best possible position under these circumstances to assure that there's a fair and just outcome. It's better positioned than an appellate court to evaluate in the first instance whether a certain occurrence is so prejudicial. And I note that the trial court said the answer to the question on cross was fair, and that, quote, it did not believe it rose to the level of a mistrial. So I think there should be due weight given to the trial court who is sitting there, who is evaluating this colloquy firsthand. And the trial court's decision in that context should be afforded wide deference. And I know there is no discussion on issue 3. I'm happy to take questions on the motion, the denial of the motion to suppress. But if there are no questions, I would defer to the state's brief on that issue. Yes.
I just had a question on the mistrial. You make note in your brief that the defendant did not request a curative instruction or a motion to strike the testimony. Is it the state's position that in order to preserve a request for a mistrial, the defendant has to make those kind of intermediate requests other than just a mistrial, or is it something that, or is the state's position that we should just consider it in the abuse of discretion that the court had those other tools available to it? Had it been asked, it might have used those tools.
The latter, Your Honor. The state's position is that that motion for mistrial is preserved, but that because our case law, it's well established in our case law that a curative instruction is not interchangeable with a motion for mistrial, that should be considered in this court's determination of whether the trial court abuses discretion.
Okay.
And if there are no further questions on that issue or issue 3, the state would respectfully request that this court affirm the judgment of conviction. Thank you.
All right. Attorney Demerjian, you have 5 minutes for rebuttal.
Thank you, Your Honors. Just responding to a few of the points that the state's attorney mentioned. He mentioned that using the exact quantities of drugs is in accordance with our code of evidence. And he said, I believe he said it puts the issue in relevant context. But Your Honors, you already brought up State v. Nash, where the state took those precautions and was able to fit in with the rules of evidence 7-3 and 4. But very specifically, I'd like to turn your attentions to State v. JIQUANE, a very recent decision, which was actually just certified by the Supreme Court for review on this issue. And in State v. JIQUANE, at the trial level, the state asked the witness a hypothetical using the exact quantities of crack cocaine and heroin found. There's strikingly similar facts to our case. And the trial court made the state rephrase. And briefly quoting the trial court, as the appellate court noted in its decision, quoting the trial court, that the question as phrased came too close to asking this expert as to whether he had an opinion, as to whether someone was exactly situated like the defendant had the intent to sell. And that's really telling language, and it's starting to show that using the exact quantities, it comes too close, and we can utilize, or the state can utilize expert witnesses in putting issues in relevant context without coming too close and still satisfying the code of evidence.
But Attorney Demerjian, in JIQUANE, the issue was whether the testimony was admissible. In this case, the issue is whether the court abuses discretion in not declaring a mistrial. Aren't those two very different analyses? Don't you have a higher burden on the mistrial than on whether the court erred on an evidentiary ruling?
You're correct. That's correct, Your Honor. It is a higher burden in our case, but at the trial court level, I believe it goes to show that courts are now considering the fact that questions may not properly be considered hypothetical when they're using the exact quantity of drugs. And the state was allowed to rephrase in that question, and the question, a subsequent question came in.
No, I understand, but in this case, had there been a contemporaneous objection, maybe the trial court would have ruled like the trial court did in JIQUANE. Or had there been a motion to strike, maybe the court would have stricken the testimony. Or had you requested a curative instruction, perhaps the court would have given a curative instruction. Don't we have to consider all of that in determining whether the trial court abused its discretion in denying the motion for a mistrial?
I understand contemporaneous objections are generally favored, but again, the court did not offer less drastic remedies. It could have done it sua sponte. I'd also like to point out and reiterate.
Counsel, so you're suggesting that the court had to sua sponte become involved here rather than putting the burden on the defendant to raise the issue mid-trial? That sounds new to me.
No, Your Honor, I'm not saying that it was the court's duty. I was just bringing it up as something that could have happened as well. And again, I understand contemporaneous objections are favored, but reiterating a point the state made that the issue was actually brought to the forefront before the start of evidence. Defense counsel said on the record, "I just want to make sure that the expert can't testify to the ultimate issue." And very interestingly, something from the state before the first witness was called, the state even said to the court on the record that I'm concerned that the jury's not going to be able to distinguish the fact testimony versus the expert testimony. The court in Villalostra cited a Second Circuit decision, a federal decision, State v. Brown. And in State v. Brown, the court said that there's something rather offensive in allowing an investigating officer to testify to a defendant's intent when other reasonable inferences could be drawn. And now,
isn't the problem though that your client didn't object to the state's motion in limine to permit this witness to testify as both a fact and an expert witness? All they did was basically say, okay, but they can't violate the rules of evidence. They basically just stated what the law is, which is you can't testify on the ultimate issue. Okay, you essentially just let him in as an expert.
Yes, that was defense counsel's strategy at the trial level. But he recognized the inherent problems that the Second Circuit noted, that, this is an issue that comes up when the state reuses a fact and expert witness. It's a common issue.
Okay.
Judge Bright, you're on mute.
Thank you, Judge Algo. I want to thank you both for your participation in the virtual courtroom today. We hope to see you back in our courtroom. I think we're going to start, the plan right now is to start doing arguments live and in person in the May term. Hopefully we'll see you then. We will take the matter under advisement and we will stand in recess until 3 p.m. Thank you.
Thank you.
Thank you.